legacy builders, welcome to the first lesson of the Enforcing Your IP Rights chapter of the IP for Business Blueprint course. I'm Jenn McNeely with JWM Designs Marketing, and in this video lesson, I'm going to share with you my method for enforcing your intellectual property rights. So far in this course, we've discussed different forms of intellectual property, the rights associated with intellectual property, how and where to register your IP, how to get permission to use other people's IP, and how to grant permission to others to use your IP. In this chapter, I want to shift gears and talk about ways to enforce your rights when someone uses your protected works without permission. In the e-notebook I provided as part of this course, you will find several form letters and documents that you can download, modify, and make your own. I will explain what those documents are, how and where to use them when enforcing your rights. So let's get started. Owning intellectual property and enforcing your rights as an intellectual property owner are two separate things. As the owner, until you exercise your property rights, anyone can use your IP with impunity. While the government can bring criminal charges against an infringer, the government will not enforce your civil intellectual property rights, even if it is made aware of the infringer's intentional criminal acts. It makes no sense to go through the process of creating a trademark or registering your copyright if you have no plan for enforcing your rights against infringers. Here's another reason why you can't be lazy and sit on your rights. If you do not enforce your rights, you can lose your rights. For trademarks, failure to actively enforce your rights to use your mark can result in you no longer having the exclusive use of the mark. In this lesson, I want to share with you my method for enforcing your IP rights. Escalation of enforcement. There are two types of infringers: those who do so inadvertently due to a lack of knowledge about IP rights, and then those who intentionally use other people's intellectual property without permission. No matter which category an infringer falls into, I do not recommend filing a lawsuit as your first response to an infringement. Litigation can get really messy and really expensive, and it should be a last resort after other avenues of dispute resolution have been attempted. As the owner of a right, you could be missing out on an opportunity to reach a mutually beneficial agreement with the infringer where you receive royalties from the authorized use of your protected materials. What I say all the time is, don't burn your bridges when you can just add a toll booth. Also, before you take any action to enforce your rights, you need to be sure the person or entity is actually infringing. Make sure you review the fair use lesson in this course before taking any action. When you think about enforcing your IP rights, I want you to picture a pyramid. The bottom level is where most disputes are resolved because infringers, once made aware of their illegal use of protected material, generally respond by not using that work or entering some sort of agreement to use the work. This level is the least involved level of enforcement. At this level, I recommend that IP rights owners send what is known as a cease and desist demand letter, which asks the infringer to stop the unauthorized use of your intellectual property and to never use it again. This is always the first step you should take when enforcing your rights. With cease and desist letters, it's all about setting the right tone. Depending on the nature of the infringement, the tone of a cease and desist letter can go from a friendly request to an aggressive demand. For example, if the infringer's use of your intellectual property is impacting your business in a significant way, I would opt to make a more direct and aggressive stance in your letter and demand immediate action. Again, the tone of your cease and desist letter is definitely something you need to take time to consider before sending it out. In your e-notebook for this course, I have created two templates that you can modify and make your own for a cease and desist letter. Whether you use my template or create a letter all your own, you should make sure that the letter includes these elements: who you are, identify the intellectual property that is being infringed upon, identify where or how you believe your rights are being infringed upon. If your IP is registered, include the registration identification number, the action you want the infringer to take, whether it's take down, destroy copies, whatever, the amount of time the infringer has to respond to the demand, and your contact or your attorney's contact information for any response. The next level of the pyramid is split into two parts and depends on how the infringer responds to the cease and desist letter. Oftentimes, infringers don't realize that they are illegally using protected materials and they do want to correct their actions. Some infringers simply stop using the materials, while others may respond by requesting permission to continue to use the materials. They may want to negotiate a licensing agreement with you or hammer out some other terms. But for some knuckleheads out there, the process of enforcing your rights may become a bit more involved if the infringer responds negatively to your demand that they stop using the work or simply decides not to respond at all. Either way it goes, you have to be ready to impose your position if you want to maintain your exclusive rights to use the intellectual property. For those that ignore your demand, oftentimes they believe that if they don't think about it, nothing will happen. For some, they may want to see if you will file a lawsuit before they take action. Because a cease and desist letter has no binding authority over the recipient, some infringers will refuse to take any action until their hands are forced. There are also a category of infringers who, for one reason or another, do not consider their use of a protective work to be infringing. Some infringers will argue that their use of the work qualifies as a fair use and that protects them from liability. But as you know from going through this course, fair use is a determination that can only be made by the courts, not by you and not by the infringer. Others may respond to your demand by challenging your ownership rights in the material. They will likely have done some research to see whether you are registered as the owner of the intellectual property. This is where registering your intellectual property before sending a demand letter could make a tremendous difference in how the infringer responds to your demands. Remember, with copyrights, you have to register your copyright before you can file a lawsuit. Another thing I want to mention at this point is that if you want to reach out to the platforms in which these individuals may be using your copyrighted or protected materials, that may be a challenging prospect as well. Some online platforms will not respond to your request for a takedown until they know that you have actually registered that piece of protected material with the U.S. Copyright Office or with the Patent and Trademark Office. Some of them just don't want to get involved in the scrum and the gray area between you and another individual because they don't want to necessarily do the research to determine who actually owns the rights to whatever the material is. You can send a letter to them, and there are ways to be able to send a request to some of these platforms like Facebook, Instagram, and other social media platforms. But I just want to warn you now, that's not always going to be the easiest way for you to be able to get the person to take it down. The quickest way to get someone to take down your copyrighted material is to contact them directly and see if they are willing to do so. If they're not, be prepared for litigation. The next level of the enforcement pyramid would be to file a civil lawsuit. If you want to enforce your IP rights, you may need to file a suit in court. While there are some state law claims that can be made in relation to an infringer's actions, in most IP cases, you will want to file in federal court. Your attorney can advise you on the specifics of jurisdiction and the allegations that you can make in your complaint. But filing a lawsuit is actually not the last step. After filing your infringement suit, the case can be resolved in mediation, arbitration, or a negotiated agreement. And while your case is making its way through the judicial process, your attorney can request that a court issue an injunction or temporary restraining order which prevents the infringer from continuing to use the challenged work until the case is resolved. A lot of times, these social media platforms, when you want someone to take down your copyrighted material, if they see an injunction or a court order, they're more likely to respond with the takedown than if you were to just ask them to take it down right away. There's a couple things I want to mention at this point. First, no matter how strong of a case you may think you have against an infringer, courts have a lot of discretionary power that could tip the scales in either direction. There is no guarantee that your case will turn out the way you believe it should simply because you filed a lawsuit. There are things that you can do to make your case stronger, like registering your IP, being diligent in looking for potential infringers, and displaying your copyright and trademark symbols every time you use your property. But in the end, no matter how diligent you may be, there are no guarantees and litigation may be your only recourse. The second thing I want to mention is that lawsuits take time to work their way through the court system, and the longer it takes for your case to resolve, the more expensive it will get. I don't say this to discourage you from enforcing your rights, but I want you to be prepared for this outcome. You need to prepare yourself and your budget before you file a lawsuit. Lastly, I want you to know that hiring an attorney who specializes in this area of law is very important. When interviewing a potential attorney, ask them about their experience in this practice area, how they've handled adverse actions, and their plan of attack for your situation. Do not be shy about asking for information from your attorney. They should not take your desire to understand your case as a slight against them. Attorneys not only serve as advocates, but they are also advisors and counselors. Be honest and open with your attorney because you're going to be working closely together with them for the duration of the case. A common question I get regarding the enforcement of intellectual property rights is how do business owners keep a lookout for potential infringers? Depending on the popularity of the intellectual property, you may need to conduct periodic searches both locally and nationally for names, images, or works that are similar to yours. There are private companies who are willing to do that for you and offer you reports on potential infringers. Another source would be to check the publications issued by the U.S. Patent and Trademark Office and the U.S. Copyright Office, and those publications include recent filings that their offices have received. You can review these recent filings to see if anyone is seeking to register a work or a mark that is the same or substantially similar to yours. Some IP attorneys also provide services to monitor potential infringers for you. Why doing nothing is not a good idea? Failure to act could leave you without means of enforcing your rights in the future. You have to be proactive in protecting your intellectual property rights, or you risk losing the exclusive right to use and profit from your property. It's really that simple, guys. You snooze, you lose. Let's recap. In this lesson, I talked about the enforcement pyramid and tips on protecting your exclusive rights in your intellectual property. Your action steps for this lesson is to download the JWM Enforcement Pyramid and Checklist and implement an intellectual property review calendar in your business. Map out your plan for enforcing your rights against potential infringers. I also encourage you to start researching intellectual property attorneys in your area. Check out a list of potential resources in your e-notebook. Alright guys, I hope you found this first lesson on enforcing your IP rights to be helpful. Please post your questions or comments on this video in the comment area below. You can also post questions and comments in the private Facebook group for this course. Remember, you can find me on Facebook, Instagram, and LinkedIn, and my handles to those sites are listed in the course resources area as well as in your e-notebook. Alright guys, that's it for this lesson. So until I see you in the next lesson, keep building, y'all.